You're live.
And welcome, folks. This is House Corrections and Institutions. It's Wednesday, April 15th. We're looking at a proposed amendment that would come from us on H 955 based on conversation this morning. Bonded amount does not have an impact on our correction on our capital bill. This language was drafted up, sent to me by John Gray, our legislative counsel, but I think Representative Kimball quickly wrote it up. He submitted. Ways and Means is having an amendment looking to some technical issues, and they'd like to include an amendment from our amendment in their amendment. So we really need to work on this. So Tate, if you could scroll it up so folks can see the full. This is in the award of construction aid section, and it's where the treasurer would report to the finance committee, ed committee, waste and means committee. We're adding our committee and Senate committee. And then our concern was what the potential impact might be on capital bills if that bonding policy is totally used up for school construction. And I don't think this is quite strong enough. Nope. I think we've got to wordsmith it a little bit. So, Troy, you had a thought?
Yeah, I'm just trying to figure out where I want to insert it. So I want to get the committee stuff out of the treasurer in consultation with with CDAC shall recommend. Then I'm going to skip this. The annual total state bonding support available for the capital budget and this program. So it's somewhere in here we want to say and any potential impact, expanding the debt capacity to include school construction will have on, capital bill allotments. Something I'm post lunch. Hold on.
Yeah. Kind of need John here.
Well, after program, you could do and this program's impact on, right?
Yeah, but it's just clunky because there's so many ands in there
A lot
already.
of ands, yeah.
So I'm gonna type here
Including
for a
the
second.
and, though, including the impact, blah, blah, blah. Well, it's only lots of ands because there are lots of committees, right? Treasurer shall recommend to these people.
We just texted John. Heaven knows what he's doing.
I don't know, I'm saying it's either, if after for the capital budget in this program, you say including the, like, I'm not saying it's the exact word, but instead of and, say including the impact on the capital budget, blah, blah, blah.
Yeah.
Not literally blah, blah, blah either, but.
Why does it have to have on? Why can't it just say committees on education,
Recommends. So-
ways and means,
I
and
don't know.
corrections
They
institutions?
don't even go there.
Okay.
That's the way it's drafted.
All right, all right. It just seems.
Well, I think,
This is what they're called.
no, the word, the term.
On.
Word on.
Yeah.
No. It's the word on.
I'm stuck because this isn't presenting it as an expansion of because this is just a new recommendation now. It's not an expansion. It's an expansion from what we currently how we currently do it. But that I can't figure out how to do this inclusive. Typing it isn't helping either.
Oops, trying to let John. No.
Doesn't have anything in his mouth.
It's a slice of pizza at 9
What do
a.m.
you think?
The annual total of state bonding support available for the capital budget, this program. And I just want to get impact on the capital budget.
Hey, well, you lose the cash fund, that's the info.
Why can't that be
There you go.
Let's put a comment after programs,
including
the impact on the capital budget,
No, we don't.
comma, and the annual debt service subsidies at the end of this chapter.
something like that?
Let me know when you're doing that, I'll make other arrangements.
After program
Yeah.
and the impacts of the Not even and.
Oh, how about a new paragraph? Hold on.
Oh, we're only.
Something like the recommendation, hold on, let me catch myself up with my thoughts and my words. Recommendation, so just clean break here, period, new paragraph. The recommendation shall include an analysis of the extent to which state bonding for school construction
Sure.
Impacts.
Affects overall capital budget capacity, including any resulting
It's not-
constraints.
That's ways and means. They don't like it that complicated.
You're gonna add your first line in the waterfall.
I don't know if we want to.
I wouldn't put it in a paragraph, they'll just scratch it,
Hold on,
the whole
I
thing
just
out.
lost my note. Let me. get my
bury it
notes
in
back
that
up.
paragraph.
We gotta be simple and succinct,
Right.
because the chair of Ways and Means emailed back to John Gray with Darren Kimball and me that this looks great to me. Thank you.
In reality, once this thing goes over to the Senate, it's gonna be a strike all. So it's kind of a moot point.
We've gotta protect our capital
Mhm.
budget. We've gotta get some language in there to protect our capital budget. Whether it's taken out or not, people still need to know that there's an impact to our capital budget.
This may not work.
One way of doing that is voting no on the floor.
All right, can I try this again?
Sure.
The recommendation shall include an analysis of the extent to which the use of state bonding for school construction affects overall capital budget capacity, including any resulting constraints on other capital priorities and projected impacts on future debt service.
It's a little too much. Read that first sentence that you did not go into.
The recommendation shall include an analysis of the extent to which use of state bonding for school construction affects overall capital budget capacity.
Leave it right there.
Yeah, I like that. I think that's great.
You don't want to future projections on future debt services? I'm worried about the trickle effect on like future capital bills, like,
If Ways and Means is gonna allow for this amendment.
What about total state bonding support for this program and its effect on the capital budget?
Like it. Simple.
Well, on it was John.
overall, do you want that or overall? I have overall capital budget capacity.
Yeah, but essentially, and I assume it's obvious, I'm saying tease it apart. So like, first we're looking at this program and then we're looking at its effect on capital budget as a whole. That's how you solve the sentence.
You want to, I'm still looking at a new sentence.
Yeah, no, sure.
The recommendations, is it recommendations? I'm in my notes.
Shall recommend, yeah.
Recommendations shall include an analysis of the extent to which the use of state bonding for school construction and renovation, probably, right,
For school construction.
affects overall capital budget capacity.
Sure.
Leave it at that. And just add that sentence after, under this chapter.
Yeah.
Risk to.
Yeah, under this.
So you take out annual total state bonding support available for the capital budget, or you keep that in?
I keep everything here and just add
Okay,
that
add a new
sentence.
sentence.
Say it again, Troy, one more time.
The recommendation shall include an analysis of the extent to which the use of state bonding for school construction affects overall capital budget capacity.
And now with feeling?
Make me believe it.
Sell it. Going back to Sean and I's original point, I guess they're different but similar, is you can put something after program. Now, one thing is assessing the direct impact on the capital budget and the annual debt service public lot. So it's simple wording, very simple, but it may not cover what you guys want. And maybe it does. But as to Alice's point, the more complicated you make it, the harder it's going to be upstairs. So, I mean, Sean had a little different words and I had different words originally, but that's one option is, capital budget in this program and assessing the direct impact on capital budget, blah, blah, blah. But it could be something completely different, but it really just one set a little words after that program. Probably seems to me like the best place to put it, and it's simpler, better, the simpler the better, as long as it covers the fact that we want to assess the impact that it has on this book. That's my opinion.
Why do you want to put that paragraph in?
Paragraph, it already is.
No. Why do you want to put the whole?
He's not putting a whole.
I'm just adding a sentence,
Just adding a
and
sentence.
mostly because that's a really long sentence already. That's one sentence right there.
Right, so it's like, it's tough to add.
Yes.
Already drawn on set.
Yeah. That's why I just added a sentence.
Okay, gotcha.
So we keep everything that's in highlights there.
Yeah.
And then on line 12, after, under this chapter, we add a new sentence.
Mhm.
And it reads as,
I'm gonna send it to you all right now. All right, sent, but it's gonna take a few seconds to get to you by email.
So, right.
No. There it is. You sent it to.
yeah, the recommendation shall include.
I haven't gotten
I haven't gotten it yet.
Not my part.
Amen.
It's waiting on
Thank you. for-
technology now.
Feel like an ADS in here.
Did you send it by email?
I did.
Council of State Governments, but not that.
To our elected department.
Yeah, I got it.
No, he always sends me stuff like that. It's just gonna take this. Yeah, okay.
Got it.
You might have Troy's stuff gone to spam, Mary, for the stuff you sent.
We're right there.
Prague stuff.
Ever bullshit.
I was using nicer language.
It's looking at your file marked UFO study.
I'll say Hedrick on camera.
There it is. See?
Why is this information important? It's popping up at the bottom, is that on? Huh. So where's the committee on this?
Yeah, I think it works. I think John might tweak it anyway, so, but it gets the point
But I
across.
think it, yes, does fit.
Can you get rid of to which the use of to just analysis of recommendations
Well, you got the extent in there.
of the extent that state bonding for school construction affects overall capital, you know. Which the use is fine, but you could also use extent that state bonding. Anyway, it's just an idea. It loses for.
Give it to Greg, hand it over to Greg.
Yeah, the intent's clear.
Okay, I'm gonna send this sentence, the recommendation shall include an analysis of the extent to which the use of state bonding for school construction affects overall capital budget.
Yeah,
Yes,
line to add it to,
Yeah,
end
I'm
of
gonna
line 12.
send that. to John Gray. I'm not gonna include the others yet.
Yep. Yeah, that cleans that other 2-page amendment right up.
Did you say that with a straighter face? There you go. I love that.
line kind of guy. I like it.
You know, I had my reservations, but it's all okay now.
Yeah, leave your mark on it too. Come on.
Here to help, Joe. I'm here to help. I just want you on board.
Yeah.
I don't know what to correct me if someone did.
Senator John. It's just income folks. I'm trying to also let what's from the. Right, to look like it's coming from you, Troy.
Let's cut and paste it.
Yeah, I didn't.
Make it look like it's from Kevin, it'll be a much better received.
It's out in the public.
I love that.
See. Sitting in for John. So is Jared in the waiting room or is he?
Yes.
So we're gonna shift gears back to the forensic.
Excuse me.
So let's pull out S 193. In front of you folks, and we have with us Jared Bianchi, who is Deputy State's Attorney. Is it Bennington County? Yeah, down Bennington County. And your name, Jared, was recommended. You were recommended a few times to have you come in and just briefly give us insight and summaries of what you have experienced in your world of state's attorney in terms of working with folks with criminal charges who either have competency issues or possibly not guilty by reason of insanity, and how that all, what you've seen in your world, because we're trying to figure out how we go forward with the forensic facility. And it's appropriate to house these folks in a forensic facility that would be within the walls of a correctional facility. It could be a wing, it could be a living unit pod. We're just not sure how that's going to play out just yet. So welcome, and if you could identify yourself for the record.
Madam Chairperson, thank you very much for the opportunity to you and to the committee to address you today. My name, for the record, is Jared Bianchi. I am currently a prosecutor in Pennington County, and just by way of introduction, the way that I come to this topic is in my current role as prosecutor, but also prior to that, I spent more than a decade with the Attorney General's office, representing the Agency of Human Services and all of the various departments within it, including DOC, DMH, Dale, et cetera, in administrative litigation and in state and federal trial and appellate courts. And I had previously been responsible for all public guardianship and Act 248 matters. I've also served on legislative study committees regarding competency, sanity, and forensic care, as well as the Judiciary's Advisory Committee on Mental Health in the Courts. So that's a long way of saying I've sort of been dealing with this issue in some capacity for the full extent of my career thus far. And I understand that the committee's ask is not to sort of do a deep dive into the bill, but to understand what we see on a day-to-day basis. And S193, from my perspective, is a very important bill because it addresses an extraordinarily narrow population, but it is the most acutely necessary population to address with a long-term secure option. Right now, the setting, if you will, is when a case that would fall under the contours of S193 occurs, and that would be a life offense. So in large part, that is sexual assaults, murders, kidnappings, with some, that's essentially what we're talking about here. It is very difficult to look at a person who has been impacted by one of those crimes. And when you start to understand that there's going to be competency or sanity issues that arise, explain to them that if that is the outcome, then in all likelihood, they're, whether it be a stranger to them or it could be a family member who they've been trying to help for a long time, that what the system allows is for 90 days of what in most circumstances at that point will be an order of non-hospitalization, meaning an order to, go connect with your local designated agency and go home. That is the vast majority of these cases, and people are, re-traumatized by that in many respects. The person basically goes home. That is both if they have been adjudicated not guilty by reason of insanity or to not be competent. And the result of that has been that we are spending an inordinate amount of time, especially with competency cases, litigating the question of whether the person is competent in the first instance, instead of moving beyond that to see whether they can be restored to competency. I have one case where we've been litigating that issue for, I believe, 5 years now. And the reason being, of course, because we don't have a process to return that person to competency and keep the community safe during that process. And because of the public safety concerns around the release of that person, a lot of concern that if we were to move to a different posture, that they would go home and we might repeat the cycle again. So the need is serious, and it's easy to sort of imagine that this is not a big deal because it doesn't touch a lot of people, but the people that it does touch, it changes absolutely everything about their life. And I would just point out that oftentimes victims and family members who have been trying to get these individuals additional services prior to these moments are often the same person. I had a case where a father trying to help his mentally ill son was stabbed in the neck. And he almost died. He was cold to the touch by the time law enforcement made it to the house. And having to work through with him the best way to address that case in a manner that kept him safe, but also, frankly, his son safe, was very difficult. So there is a need here. And we believe that the structure of the bill does meet that need for this population. I know that there's been some conversation about sort of questions of implementation. And I would just point out that I think some of the flexibility that's in the current structure of the bill is going to be important because the population is both very small and frequently shifting. And so you're going to want to allow the implementing agency to address the therapeutic milieu, if you will, in a fashion that allows them to meet the particular individual's needs. We don't have sort of an economy of scale like the state of New York, but that does give us the opportunity to be more creative depending on the actual population that you're dealing with, and to try new things if something isn't working. I know that also some of the conversation has been around, possible, what's the scope of what's permissible on as a constitutional matter. And I would just point out that if something is not constitutional, it doesn't need to be also stated in the legislation that is the existing law, whether or not it is recodified here, and that any of those disputes can be resolved through the court process. But a lot of this bill comes from a similar federal process, and we are an outlier state. Most jurisdictions do have some degree of ability to address both the not competent and not guilty by reason of insanity population with an eye toward meeting their needs, yes, but also protecting themselves and the public from their dangerous behavior. One of the results of the protracted litigation around questions of competency and sanity is that, and in my experience, you're typically talking about an attorney for the state who is, of course, public sector, a public defender who is public sector, and the increase in the resources just in terms of monies that are necessary to hire consultants, hire evaluators, have them testify, and to go through that process. I think that it has an inflationary impact on how much of that we need to do when ultimately what we're trying to accomplish is not trying people who are not competent. The state doesn't want to do that any more than the defense does, but to have an individual who is able to access the process that is due to them to put the state to its burden of proof once they're able to access that. And so accommodating them to be able to put the state to its burden of proof and access that due process, we think is an important goal, and one that I think would give a great deal of clarity to these cases that seem to go into a bit of a vicious cycle, if you will. Well, I know I've been going for a minute, so I'm just curious if there's anything in particular that you'd like me to address.
I just have a question, and this is two-part. So under this proposed legislation, if there was for competency restoration, there was a court order for non-hospitalization competency evaluation and restoration. Under this proposed legislation, and it was a criminal offense that would qualify, where would the person go for that non-hospital evaluation?
So you're talking about under current law or under this bill?
Under this bill.
Okay, yeah, so this bill really, for this particular population, doesn't use that non-hospitalization. What it makes clear is if the person requires a hospital level of care, they need to be in a hospital, be that the hospital in Berlin or for any other need. I mean, they might have just a regular clinical need, and like any other person who's held without bail, if the Department of Corrections can't meet their need, then they need to be at a hospital level of care. Under this bill, they would be at a facility that meets the definition of forensic facility to receive the periodic competency evaluations and the other care that they're entitled to. I'm not aware of a particular site that's been identified yet. I'm not sort of on the operations side of things, but it would be in a setting that would meet the definition in this statute, and that would provide for a secure placement that would protect the community from the behaviors that brought us there in the first place.
So I want to do this step by step. So the court has ordered an evaluation of competency, and it's a non-hospital order.
Gotcha.
Doesn't need to go to a hospital for it.
Mhm.
Under this legislation, they would then go directly to the forensic facility within a correctional facility, correct?
Well, let me back up one step. So it would not be until there is a finding of incompetency. So they're almost to a person.
Who would do the finding of competency?
Yeah, the finding of incompetency is made by the trial judge.
Okay.
So this part of the, when a person is arraigned and arrested for, let's just use a murder, for instance, generally speaking, that person will be held without bail pre-trial. And it's at that point that we begin the process of, the defense may want a competency evaluation, we may want our own, and then eventually that will culminate in a hearing on competency. All of that happens before the trial judge. Under this bill, if the trial judge says this person is not competent right now, they would go to the forensic facility and they would be provided periodic competency reviews, and they would be provided services necessary to restore them to competency.
Within DOC and by DOC folks?
That would be my understanding would be that it would be care providers, probably either contracted or employed by DOC. Yes, and that the security would be provided by DOC folks, is my understanding.
So there's a court order for competency, and the person, it's a hospitalized order. What happens in that situation? Does the person goes
To the hospital.
to the state hospital?
Yes, or I think the hospital or the retreat has been my experience.
Okay, so would they be held as a detainee first before the court determines that the person's not competent and then has a hospitalization order?
So the way that this dovetails with existing law, in if I'm understanding your question correctly, the person would be arraigned, they would be held without bail. But generally speaking, when there's a request for a competency evaluation, whoever's requesting it, and it could be the state, it could be the other side, can ask for an inpatient screening. If they screen inpatient, whether it's at initial review or if it's determined even by DOC, I've had DOC actually have them hospitalized based on a level of need before, they would transfer from wherever they are to a hospital level of care. Whether that's in DOC custody or elsewhere, they would not be held despite their level of need. They would have to be somewhere that meets their level of need.
So if they got transferred to a hospital, it was hospital care that was determined by the court, how long does the person stay in a hospital setting?
I'm sorry.
Right now, how long would they stay in a hospital setting?
They would be at the hospital setting until the physicians at the hospital determine that they no longer require that level of care. I have seen people stay for very short periods. I have seen people stay for very long periods.
How long is a long period?
So if you're talking about requiring a hospital level of care,
Yes.
and in my personal experience, and again, I don't have data. I think somebody from VPCH might have better data on this, but I have seen numerous months where a person could be even at that highest level of needing that hospital level of care. And then I have also seen folks who would discharge and then require that level of care again and go back, and that can go on for I've seen that go on for a couple of years, even on a pretrial basis.
So in the scenario where the court has ordered a hospital level of care to determine competency, under this bill, where does the person go?
The person would still be entitled to go to the hospital. This is only for people who do not require a hospital level of care. And I believe that's spelled out explicitly, that if a person requires a hospital level of care, that they are too acute for this facility if they require a hospital level of care.
Well, says is not currently receiving treatment through an order of hospitalization.
That is right. Yep.
But there is an order of hospitalization, but they're not receiving treatment.
So if you look at the definition of forensic facility, it's specifically defined as providing evaluation, treatment, and care of persons involved in the legal system who do not require a hospitalization level of care. And so setting even now, if a person is held without bail by the court, that does not prevent them from going to the hospital if they require a hospital level of care. They go to the hospital and then they discharge back to the facility. It's not envisioned that this would be any different if this bill were passed. A hospital level of care is a level of care above what I believe the forensic facility is expected to treat.
I'm confused. On page 1, line 16 through 17, for a person that would qualify to be in a forensic facility in DOC, the person needs to not be currently receiving treatment through an order of hospitalization.
That means an order of hospitalization has not been applied,
It's not been applied.
right? Rather than I see how you're reading it,
Yeah.
but that's not how I read it.
I think, Madam Chair, that if the person requires a hospital level of care at any time, they would then currently be receiving treatment through a hospitalization order. So that could spring into effect after initial remand. That could happen later, and then they would then be receiving treatment through a hospitalization level of care. Through a hospitalization order, I'm sorry.
Go ahead.
Yeah, thanks so much, Jared. This is really helpful, especially hearing about the sort of the front end of it, which we don't deal with it as much. And I agree with you, like we need to allow some flexibility in this, but I think we do need to make the decision of who we're charging to develop this plan and who ultimately is going to have custody of this population. So I'm wondering, and what I'm wrestling is, how do you see the Department of Corrections being better equipped to restore competency of this population than like the Department of Mental Health, whose very mission it is to, work in psychiatric care? It's I'm just wondering if it's in the right place here.
I think that's, and I'm glad. So I do want to address that. I just want to come back to the chair's question about hospitalization very briefly. There is language in the section 3 that does state that nothing in the section should be construed to prohibit the temporary transfer of a person requiring hospitalization level of care. I think that any concerns you have about that transition between the two levels of care could be accomplished by having that type of language in that first section as well. And that's section 3, just subsection A in 481A.
Page 618.
With respect to the Department of Corrections, so it's been my experience with a couple things, and this committee is probably already painfully aware of that, so I apologize if that's the case, but the Department of Corrections is the only department who is responsible for all of a person's needs. And they're responsible from socks to food to medical care. And that includes healthcare, and that includes mental health care. We provide medication-assisted treatment through DOC. And Vermont is also a bit of an outlier state in the sense that our Department of Corrections is part of our Agency of Human Services. That is historically, to my understanding at very least, not the structure that other states have done. So DOC has a bit more of the embedded ability to access those other departments that you referred to. But what we want to avoid here is if you were, for instance, to put this under, the commissioner of Department of Mental Health. Well, that commissioner has a very specific jurisdiction, and that's really grounded in the definition of a major mental illness. And what you can see is people who are not competent for any number of reasons that don't fall under the auspices of a particular commissioner within the Agency of Human Services. Whereas the Department of Corrections does serve everybody. Let me give you an example. I have had a case where an individual was determined not to be competent because they were hard of hearing, but they were not especially good. They didn't know American Sign Language very well. And so that impacted their ability to participate in the proceedings, consult with their attorney. And that is something that could very readily be provided with an appropriate plan, training, education through this bill. But it would not, that's not something that would be the responsibility or the jurisdiction of the Department of Mental Health. So the intention here is to really get away from the sort of what I call the diagnostic silos that exist in the current law. Because right now, if you don't satisfy the criteria of one of two specific commissioners, you just go home. There's not even an O&H. There's nothing. And there have been circumstances where, for instance, sexual assaults have occurred, and the neighbor who did it goes back to live next door to the victim again. That's not an outcome in those types of cases that we want to continue to have. Most states that would not be the case, and it shouldn't be the case here. I would also suggest that I think with the authority envisioned in this bill, my guess is that it would not simply be precisely what DOC does now, but also with this population, that you might also see some additional folks brought in to really implement this in the way that you're thinking. And in that context, there would be no reason why it couldn't be this commissioner versus that commissioner. And without the sort of the jurisdictional confines of, for instance, the Commissioner of Mental Health or Dale, we don't have to then expand those other definitions that could have knock-on effects for instance, the civil process that occurs for people who are not forensically involved.
So can I just follow up, Jared? Like, if you close your eyes and envision what does this facility look like, because we're the institutions committee too, we have to build it, right? What is the best case scenario on that, do you think? Or is it a facility at all? Because I think one of the worrying things I'm hearing from corrections is we're going to hire a few new staffers, but otherwise it's pretty much status quo. They're not necessarily in a separated unit. There's nothing different or more clinical about the environment they're in than exactly what's happening right now. And to me, that doesn't sound like too much progress necessarily.
So I think it's, so again, I want to be clear, I'm not responsible for implementation, so I don't want to get too far over my skis. But I could see a facility that, whether it was a separate facility, a separate unit, or something like that, that would have distinct treatment, that would maintain security in a way that would use locks and things like that. I would expect that the living situation would have to be appropriate to the person's need, because they're not there as a punishment. They are there either as a pretrial person whose competency needs to be addressed, or as a person who's not guilty by reason of insanity. That those folks would need to be addressed in a way that is consistent with those needs, and not simply as a punitive measure, which is permitted for the sentenced population. I will point out, though, the other part of this bill that is not, sort of four walls and a locked door, but it is corrections, is the existing ability of field staff. So if you look through this bill, there are opportunities for this population to have access to the community, but under supervision. And DOC has the existing staff in each county to supervise this population and to monitor these orders in a way that has been problematic on the mental health side for some time now, and really not appropriate given the security concerns by who historically has done that, which is the designated agencies. So that there is the opportunity here also for a sort of a more broad spectrum than just envisioning this as a bill that creates a facility. It's a bill that creates, I think, a legal infrastructure that the court can then have some flexibility to determine, okay, is this person's risk such that they need to be somewhere locked? Or, as a result of, the facts in the particular case, is this somebody who we can serve and monitor and see how they do on the outside while we're addressing, the true populations that are seen here? And that's really something that exists, to my understanding, really only within the Department of Corrections, with that the access to both facilities and field staff who are already there.
I missed a lot of this because I was dealing with our police meetings. So, sorry, Mary.
Jared, thank you for doing what you do in Bennington County for our state's attorney. Are you speaking today for yourself or for the state's attorney's office?
I'm speaking for the Department of State's Attorneys and Sheriffs, and I'm happy to share that all of the state's attorneys support the passage of this bill. All of the sheriffs in each of the counties support the passage of this bill. It is designed to address the most acute population, not your jaywalkers, not your folks who are disruptive in the street and just generally disorderly. This is a very specific population, and because of the small size, it's hard for me to be, if we were in New York State, right, I would say, yeah, well, there'll be a building. I don't know what DOC specifically will do to implement this, but I do see the need to have the legal infrastructure in place to allow this to occur. And it does make sense to me that a department with access to both facilities and field staff would have the flexibility to do that in a way that's probably more possible for them than for other departments.
No, and I agree. I wasn't questioning that. I just, as you came in, I might have missed you saying that you were testifying on behalf of the sheriffs and the state's attorneys. So I appreciate your testimony greatly.
No, thank you, Representative. So I hope that I've been addressing sort of the questions that the committee has. I have some of the other points that I would just briefly make, if you'll allow me, that this really is an issue that does touch each county. There are cases that are impacted by either, life offenses in each county that impact families in those counties, and it really does run the entire state. This is not just a Bennington only issue. It's not just an Orange County issue. And we have said in other committees that we expect, I think the thumbnail sketch is probably there's about 5 or so cases in a given year that would fall under what this bill seeks to accomplish, if that's helpful.
So when you say 5 cases or so in a given year, is that 5 new cases, or you're saying 5 that are ongoing?
So I would see that as, and again, that's a give or take number. I would say there are probably 5 new cases or less in a given year where, for instance, competency is at issue in a life offense case. The person, the hope here would be that the person is restored to competency and then can access their due process and put us to our burden and go through the trial process. That's the ultimate. It's not to accumulate people in this particular legal structure, but it's to provide clarity about what happens next. You have a non-competency finding, but right now there's no off-ramp. There's no process to address that, either from a security perspective or from a restoration of competency perspective. So for this population, that seems to be an acute need. And then, I have recently had a case where the verdict was not guilty by reason of insanity. And while that was not a life offense, I can just explain sort of what happened next was we had a hearing. The person did not require a hospital level of care. At that point, it was far after the events that generated the case. And there was I believe a 90-day order of non-hospitalization, if that even. And they went home. They went home next to the neighbor whose house they had entered and threatened, and into the same community, but without any of the protections that we have here. And while that may not sound as concerning in a non-life offense case, there's no distinction here in the law of today that would have made it any different for that population.
So when you say there could be 5 cases per year, and it could be 5 new cases the next year, 5 new cases the following year, some folks may have restored competency that could stand trial. So maybe after 5 years, we could be housing 20 people, not just 5.
Well, so I guess I can't say that that's not possible. I mean, again, I think with restoration services and plans in place, the hope would be that we would not be accumulating additional people, but that this would be a zone where that person's needs could be met and then returned to the pretrial process. But I can't say that it's not possible. And what I can say is, the not guilty by reason of insanity population is very small. So I can think of maybe a couple in the last decade who would fall under this particular legislation. And the not restorable population, there is at a certain point, in this bill, it envisions moving more to the supervised release, and then there's other motions and motion practice that would occur in court probably to resolve, for how long should the underlying docket stay open, things like that. So I can't say it's not a possibility under the legislation, but I also would caution you that the likelihood of everybody going in here and just staying in perpetuity is that is not my expectation, because they also have attorneys who would be fighting, first of all, to have people released, but then second of all, probably to try and dismiss cases.
So when they are released, they'd still be monitored in the community by DLC. So in essence, they're still under DLC.
Under this bill, as long as they are subject to the provisions here, they would be, the court could issue conditions for their supervision, including treatment conditions and other conditions, and those would be monitored much like, the best example I could use is like a condition of probation or something, where the field staff can go and make sure that you're going to your groups, you're going to your doctor, you are living where you're supposed to live, that you're checking in with them periodically, things like that.
Sean.
Jared, do you have any data for the last 10 or 20 years that shows the average number of people that are that we're holding that are under this small category?
So I have gotten data from the crime research group about not guilty by reason of insanity. I believe that there were, I think, one shown on the table and then another one that I'm aware of that would have fallen under this bill. So over the last 12 years, I think it was the judiciary coding.
It's not the not guilty by reason of insanity, it's the restoration of competency.
Okay.
That's the
Okay.
one. It's
All right.
not
So-
so much the not guilty.
So-
And so for that population, I did ask for, I asked the crime research group actually if it would be possible to pull numbers on that. And my understanding is that it hasn't been tracked by the judiciary to the degree that would give me sort of the ability to tell you a number, but I actually was curious about that and tried to work on it. So I guess the anecdotal information that we have, both as a department and also just some of the other witnesses that I've heard, has sort of consistently said that that it would serve approximately 5 folks a year based on people's working memory, but not that those people would be not restorable. And generally speaking, folks have been able to be brought to trial with some exceptions.
Okay, that's helpful. Thank you.
Other questions? Anything else you'd like to share with us, Jared?
No, I appreciate the opportunity to address the committee. I would just reiterate that it is an important piece of legislation for all the reasons that you're already aware of, but also other states have been able to do this. The language is premised on some of the federal language in the federal statutes, but obviously we have to be thoughtful about the fact that we don't have the same population that the federal government has to address. And so, some flexibility in implementation may ultimately make a lot of sense to allow the implementing agency, whoever that may be, to address the actual populations it has. So, thank you all very much.
Well, thank you.
Thank you.
Thank you for
Thank you,
taking time
Jared.
out of your day for this. I appreciate it. Thank you. I missed some of it because I was dealing with our amendment. Emails going back and forth. So we are due for WellPath. They're
Couple of them are online.
they're online, that they're not. Okay, so what's at play here with Ways and Means right now? Is, do we want this to be part of the Ways and Means Amendment? And I'm willing to do that, but I want to see the language before I give the
Yes.
okay.
Yes,
Yes.
gotta see the
So
language.
the chair of Ways and Means was fine with the new sentence that we put in. And would like to submit it for tomorrow's calendar. Maybe somebody from here could go in at 11 o'clock to present it. And then they're willing to do it in their Ways and Means Amendment, but I want to see the language before I say go ahead and do it. So I'm waiting for John to draft it. Anyway, so I missed part of that testimony. Big Jared, I'm trying to deal with this. Okay. So Haley, you were supposed to be in Rutland. What are you doing here?
She's back.
I was in Rutland in the morning, but now I'm back home, so I wanted to join remotely.
You didn't want to stop by on your way home?
No, it's like the opposite to get back to Burlington and Montpelier. So I'm sorry I couldn't be there in person today. I'm sure I'll be back there soon enough.
Yeah, you'll be back. So is Dr. Richards on at all? I see Robin Hodge. Hodge? Hodges.
Look, get together.
Oh, they are together. Okay. That's
Are,
great.
yes. Let me get rid of this background.
Yes.
Yeah, it is different background, isn't it?
Uh-oh.
So welcome, and sure, we're gonna have a lot of questions for you folks as we continue the testimony, but if you could just give us a summary in terms of how you perceive this to be carried out in your world in DLC, in terms of working with folks to help them gain competency. Because that's really part of the crux of the issue here. If you both could just identify yourself for the record too.
Hear me. So Dr. Allison Richards, and let me know if you can't hear me.
We can
I'm
hear you.
okay, thank you. I've testified before, but thanks for having me back. I'm currently one of the vice presidents of psychiatry for WellPath, but most recently was the director of psychiatry for Vermont. I'm still kind of training my replacement, Dr. Horn. And then just for a little background and context related to forensic patients, I've trained in Vermont and was the director of the Vermont Psychiatric Care Hospital for almost 10 years. So the population of patients that I was working with, there were a significant number of forensic patients at the state hospital and currently in corrections. So it's a shared population. That'll be my introduction. I'll let Dr. Hodges introduce herself, but
Good afternoon. I'm Dr. Robin Hodges. I am a psychologist by training. I'm the Senior Vice President of Mental Health for WellPath. I've been with WellPath for about 20 years, and I oversee all of mental health for WellPath in general. So testified twice already regarding this bill, so happy to take questions.
So Dr. Richards, where are you now more employed by DOC or are you still employed by WellPath?
I'm employed by WellPath.
By WellPath, okay. And you're just the conduit sort of between WellPath and Vermont DOC?
Yes, Dr. Horn just took over less than around a month ago, and so I was asked to testify. But yeah, I supervise Vermont. We're in Maine currently, so in my new role, I'm seeing other systems for state and federal. So I'm supervising Maine and Vermont's correctional systems for the prison system side of things.
So how do you see this piece of legislation playing out in your world of WellPath?
Mhm.
There was a forensic facility within our DOC facilities. How do you see that playing out with you folks and doing the evaluations and providing the treatment? And what does that do to our contract that we have with WellPath
Mhm.
and staffing on your end?
Well, I could speak generally to at least my side of like being a psychiatrist and working with forensic patients that are involved in the criminal justice system. And I would just say that since I've been in training in Vermont and a resident, I have longed for a forensic system of care. And I've been at meetings with the sequential intercept model committee meetings, and over the course of my career and especially when I was at the state hospital, and even more so since I've been in corrections, have wished that we had a forensic system because of the impact on patients and their lives. And this might be more philosophical and not as direct a response to your question. However, I see the impact of the person that's affected at the center of care, and that when we don't have a system that works to move people through a system, when they have criminal charges in a speedy trial or whatever, I see patients that languish in different stages, like in corrections. Sometimes people will be stuck in the system for months and months and months. If they're not dangerous, we can't get them hospitalized because of the statute. So there's a barrier there to getting people through our system, if you want to think about systems and efficiency, but also people's lives and helping them, in terms of competency restoration and treating people when, like I think the Vermont population is the bill speaks to a very small number of patients, some of whom are probably currently housed within the Department of Corrections. It sort of puts their lives on hold, when you have someone who's had, as you probably have heard, perhaps have had several forensic evaluations, and there's competency and not competent. We can't go to court to treat someone with medications, and someone who may very well need that level of treatment, psychiatric medications. There's no way currently within our system to do that. We can only treat them within the civil court system and at the state hospital level. And so that is also sort of it can be a barrier to get people treated and efficiently, not for us, but mostly for them to get their symptoms treated and to help them get through their charges and to get on with their lives. So I know I kind of digress, but I think we currently have several patients at our facilities that have charges, that speak to the bill, that are facing a life sentence or held without bail. We develop treatment plans for them, but it's within our current system. I'll let Dr. Hodges speak a little bit more because she has done competency restoration programs before, and me being in Vermont, we haven't had one. So I think it's an excellent idea, and I don't think it's a large number of patients. I think the programming is not necessarily that much more than what we currently do, but it is specialized. And yeah, I'll just pass it off to Dr. Hodges about like the programming and what that might look like.
Absolutely. So thanks, Dr. Richards. So I think to answer parts of your question, so WellPath does competencies for restoration in lots of different states. I think your situation looks very similar to kind of Maine DOCs where we do competency restoration as well. Yours looks a little bit different, but one thing that we do in WellPath is like, you know, part of this process is like working through your statute of like how it's going to actually look, who's going to do the evaluation, who's doing treatment, who qualifies for placement, all of those things. But we're very used to, once the statutes are kind of fleshed out, coming in and providing that clinical care. So depending on how it's set up, ultimately in the end, WellPath can come in and, well, we're already there. We would do the forensic facility. I don't have details on how it would look as far as staffing and general day-to-day, but I can kind of talk through kind of higher level what it might look like. It would look probably very similar to several of our other units where you have the basics of competency restoration. So the legal education piece, where you're working through kind of helping them understand the court, et cetera. And then also just mental health treatment in general. So their med management and different mental health groups, be that DBT, dialectical behavioral therapy, cognitive behavioral therapy, et cetera. And then psychiatric medications, and creating more of a milieu-based, something you would see similar in a forensic hospital within the unit. And so it's just more focused on treatment and moving the patient forward.
So let me just be sum this up, because the language says that the person would receive competency restoration services while at the forensic facility. So this is what I just heard you folks testifying in terms of providing that. You would need to know who does the evaluation. You would need to know who does the treatment. You don't know what that would mean for staffing, what you would need for staff. You're not sure what you would need for programming or medication. Does that sum that up?
So not necessarily. I would sum it up a little bit differently. I would say that specifically for this Vermont unit, we have not developed a staffing plan. Generally, obviously, we know that there's a clinical director involved, psychiatry, nursing, et cetera. But as far as like an FTE count, we have not gone into kind of levels of that for staffing. Programming will be kind of generally what programming we do in the other units, which is DBT, CBT, and the competency restoration, likely using the comp kit, which is just we also have one developed for Maine, which we could use, which is just the legal education piece. So we have the details fleshed out, but how it comes all together into a package of, you know, a daily schedule for Vermont, et cetera. We don't have that level of detail fleshed out at this point.
And I don't think it's, yeah, and I would defer to Haley. I think there was something in the bill about presenting that information to the committee, that it's sort of, the basics are like what we already do, I guess, a psychiatry, nursing, mental health clinicians. It's just specialized with the competency, the legal education piece, and then just working within the law for medications and doing psychiatric med management treatment plans. It's all sort of I guess I would say the bailiwick of what we do for psychiatry and mental health anyway. It's just a little niche that's carved in. And I, based on the law, that's my assumption that it's not a large number of patients because of the way the law was written with the charges.
Would the medications that you have access to in your formulary,
Yes.
would they cover the psych medications that would be needed?
Yes.
Right?
Yeah, our formularies, Vermont, we are the formulary for WellPath versus Vermont Medicaid is it covers just about everything. So it's the same medications that we use currently. And like I said, that we have several patients that in my head, I think of, oh, this person kind of fits the bill, if you will, not that they're facing a life sentence. They're in our facility already on one of our mental health units. And kind of in between, they haven't been found competent, but it may have been 3 or 4 or more years ago, and they're sort of sitting on a unit, and it's like, there's not that opportunity, I guess, for if, to try to get someone stable and focused on it and see if they could go through competency restoration. And there could be a resolution for this individual.
Yeah, sure. I was hoping to talk about the physical structure a little bit, because we say, okay, what's this bill about? It's about creating a system, but it's also, people would say, well, we're building a forensic facility, and as we kind of flesh this out, right, it's the forensic facility might not be a facility at all. It might not even be like a new unit that's renovated. It might be the existing correctional facilities that we have, right? So, the commissioner was saying that possibly Alpha Bravo unit would be what would be used for the majority of these folks down in Springfield. And it just feels like, if I'm reading the language right, this would be designed and operated in a manner that supports a therapeutic, recovery-oriented, and trauma-informed environment comparable to a community-based residential treatment setting. And I got to say, when I go to Alpha and Bravo, it just doesn't feel like that, right? It feels like a prison. So I'm wondering if you think the existing space we have is good enough for this, or if it needs to be in a more clinical setting.
Thoughts, Robin?
Yeah.
Dr.
I mean, part of this is that, and I'll defer over to Haley on this because, I mean, you're not involved in the building of the actual, like, assigning of the units and deciding where this actual facility is going to be. We're the folks who come in clinically to do what we do with whatever physical plant we're provided with. Same as, obviously we work within the facilities, which aren't always ideal, but we make it work. And so, I don't know, Haley, do you have something to add to that? Because
I think just before we go there, I think my issue here is we get one shot to do this, right? And I think we should do it right. So it shouldn't be what we're left with. It should be what we envision to be the best place to care for these individuals. So just from a clinical perspective, what is the best place to care for these individuals?
I'll just speak a little on, Vermont, knowing Vermont's system and facilities, and in my new role, I visited some jails in Broward County, Florida, and I did see a competency restoration program within their facilities that was utilizing it would be like taking Bravo unit. They were using the system that they had, which I was like, oh, this is kind of like Bravo units, not really any different, but they had, they had brought more activities out and they had shaped it. And then being in Maine, I don't know if you guys have ever visited Maine, but I've been here for the past 2 days, and I'm kind of like, wow, their facility, so I think I don't know, and then maybe that's a question for you. Do you think you have one shot? I don't know if that's, do you start a process and then anticipate getting it somewhere? Or maybe you, as the legislature, have the power to kind of say, we want to do it differently. We want to envision something different. I think we could absolutely make do with what we have. Would I like new facilities? Yes, I would. But I know that those are very costly to the taxpayers and not always the most feasible option. And so I think that's maybe part of the dilemma, really. I would love all new facilities compared to what I'm seeing in Maine, and just some newer facilities in general. Anyway, so I'll stop talking there. But I think you could make it with what you have, like what I saw in Florida. It didn't look any different than the living units that they had. And I don't know if there's a way to kind of plan to roll something out and then eventually move into something different. I don't know if you are the experts on that. I'm not as keen on that piece of things.
I would just say, I think we want to do it right,
Yeah.
and we're lay people, and we need experts to advise us on what the best place to restore the competency of these folks is. It doesn't feel like it's Alpha and Bravo unit, and it doesn't feel like that's comparable to a community-based treatment setting.
Based on the bill, I don't think I could say that's comparable. It's not equivalent to a community-based center. And, I testified when I used to run Middlesex Therapeutic Community Facility, and we maybe it was your committee that approved the new building of River Valley. I don't know if that was this committee that I
Yes, it
testified
was.
before, but, and I haven't seen River Valley, but I've heard wonderful things about it. If that's,
Great, yeah.
if that's the standard, Alpha Bravo isn't the standard, I will just share, I've been thinking a lot about this as well, because I am invested in the patients and the care they're getting, and I know what is happening for a long time. So there hasn't been a forensic system of care in Vermont. And there's, I would have patients come into the state hospital on criminal orders, and they would sit for 6 months because I couldn't get to court for medications under a criminal order because there was no hearing, because the patient was not competent, wouldn't meet with an attorney. It would delay their care for 6 months to even get before a judge. And so trying to find a way to get people the care they need and also like design, the right setting is tricky. And I also, on the flip side, I will say, in my coming into working in corrections and having worked in the hospitals and being part of the hospital community with all the medical directors and Dr. Kellyanne Klein, sometimes our patients with these charges that fit into the small number of patients aren't really manageable at hospitals. And I've seen that recently with a patient that's kind of gone between one of the hospitals and corrections. And so I guess there's another need at a certain point for, the hospitals that we run should be able to manage everyone. And yet there are some patients that are forensic, that are extremely dangerous and violent, that would be probably best treated in a different setting. And we don't have that either. And so I feel for the hospitals, because I was on that side of, when staff are sent to the ER and you can't manage a patient safely, like that is another side of this dilemma that, so I've just been thinking about all those things and I'm sharing them with you. When I think about a forensic system, I'm very like, oh, that would be amazing. I've kind of wanted this my entire career and wanting to do it right. So what would that look like? I don't know. And that's where I would defer to the DOC on the facility piece and to you as well. I always like new facilities. When I had the new state hospital, it was amazing.
We did that here too. That came out of this committee too.
Oh, yeah. Yeah. Okay. BPCH.
Yes, it
Wonderful, wonderful facility compared to the old state hospital in terms of the environment of care.
Thank goodness for Irene. Tropical stuff.
Yeah.
The way we got off the dime. Troy.
Dr. Richards, I have been looking forward to this meeting because you're a very specific person who was in the room that sources my concern around conflict of interest. So when we were doing the gender care bill and we asked, as we were putting that statute together, that bill together, we asked whether or not WellPath could be part of the process by which determinations were made about housing as it pertains to a person's identity, especially transgender folks, right? And the answer we got from WellPath, and I think you were in the room, was that that would be a conflict of interest. You don't want to be put into the place of determining a decision on housing if that decision doesn't go well, according to the incarcerated person, you are then also asked to provide medical care down the road, that it would create this conflict. I have significant concerns with the folks contracted by DOC to provide healthcare, WellPath right now, who have a financial interest in, I'll say, keeping a population in place, making determinations about whether or not somebody is going to be incarcerated, right? Somebody is going to be determined competent enough to face trial and ultimately face incarceration. Can you help me? And to date, my concerns have been pretty much dismissed at hand as just simply not a concern. I haven't gotten over my concern. So do you mind speaking to that a little bit? Dr. Richards, about why you don't feel this presents a very similar conflict of interest, compared to the conflict that WellPath identified for making determinations for housing for transgender identified inmates?
Can you remind, so when you had asked me about WellPath isn't on the housing committee for transgender patients and where they're housed. And my response was, remind me what you're saying. My response was, I don't think it was a conflict, but
It was both you and Dr. Uliger, I think, were in the meeting, right? And the worry that this bill, the gender affirming bill, the path that the needle we were trying to thread is we want to treat folks who identify as trans with dignity and care and get them the housing they want. We also want to be careful not to create a safety and security concern when people misuse that identification to get more preferred housing. In this case, people who would identify as trans women doing so nefariously just to get placed into it. And WellPath's answer, I don't know if it was yours specifically, Dr. Richards, WellPath's answer was that would be a conflict of us to make a determination in that way, because we're still going to be the people who provide medical care to these people, regardless of how we decide.
Yeah, I think, I hear what you're saying, because I think that there are numerous layers. And I think my response was like, we typically haven't been involved in any disciplinary processes that might arise as a result of, so it's not that we couldn't be on a committee, we just haven't been involved in housing situations, because sometimes there are disciplinary processes involved in that. Like if someone is wanting to get to a different facility, we tend to not get involved in the discipline piece. That was sort of where I draw the line, because our job is healthcare. So I don't know if it was completely a conflict of interest or if it's just, we just haven't typically been involved at that level because we stay out of any disciplinary reports or meetings of that level.
Right. But so similarly, these decisions, restoring competency, are going to have an impact, however minimal, are going to have an impact on an increase of the population to which WellPath is contracted to serve.
Well, so the way I'm not sure if it would or wouldn't. Like I kind of feel like the number of people we are, my goal really, and maybe that's me having worked in all of the different areas that I was speaking to, right? Like having worked at UVM, worked at the state hospital, and then moving into corrections. It may be just my scope. I can see the different layers of a person in the system and the lack of a system. And that's what I'm speaking from, really. Our job, yes, you're right. Like our job is to provide health care to incarcerated individuals. I don't know that it would increase the number. I mean, I feel like, honestly, I mean, people will be incarcerated one way or the other. My job would be to get them to the level of care they need, regardless, if that makes sense. So if we have a patient come in to corrections, that's going to happen anyway. It won't really impact me because we provide care to everyone.
Well, it would if we weren't doing a forensic facility within a correctional facility. That's kind of my point, right? Yeah.
Yeah, they would be there already, is what I think. We have a significant population already at Southern State that are either in a state of not being competent, and I mean, I don't use this word lightly, but languishing. We have a lot of patients that come in that don't get any care. We try to get them to the hospital, but the lack of a forensic system, patients fall through the hoops. We have one right now that's been in there for like maybe 8 months, almost a year. And I don't even know if the patient's attorney is aware that I don't know what's going on because I'm not involved in that part of the system. But conflict of interest, I don't know I would just say my job won't change. I'm not invested really necessarily one way or the other. My investment would really be as a Vermonter and the patients getting the care they need. And you could probably ask any other psychiatrist in the state of Vermont, like, do they think we need a forensic system of care? And they would probably say the same thing.
Oh, I don't disagree that we need it. I don't know that it should be housed within a correctional facility.
Okay.
Yeah.
Can I make a suggestion that might be helpful about what your original question was around the concern of like WellPath sort of like increasing potentially the population. So when I had made the reference around the evaluation piece, each kind of state has their own way of doing it. And so in some states, the treating folks are also the evaluators. So if, let's say I'm the treating psychologist on the unit, and then I also do your evaluation for competency. Some states do it differently, where the treating clinicians just provide updates, and their forensic state system or a forensic evaluator who's not associated with the treatment aspect comes to the facility to do the evaluation. That's how we do it in Maine. We don't actually do the evaluation piece. We provide updates to state forensics. They come in and actually do the evaluation.
That's kind of what I'm getting at, yeah. Thank you.
You're welcome.
So I want to ask some specific questions here. We have to look at the language. So it establishes a forensic facilities clinical services director. Would that person be under WellPath? Would that be an employee of WellPath?
Go ahead.
Or could it be outside? Could it be someone else that answers to the Agency of Human Services or answers to Department of Mental Health at Dale?
I'm happy to answer that question if that's okay. And WellPath, you're welcome to jump in as well. For the record, my name is Haley Summer. I'm the Director of Communications for DOC. As you can see, Chair Emmons, the bill doesn't contemplate where that position will be situated and who it will report to. I think those questions are still, left unanswered, something that DOC would address during that reporting period, likely in October, once the authority has been established through this statute. But because WellPath is currently providing care for folks incarcerated in Vermont, and they provide competency restoration services elsewhere, we've certainly been bringing them into the conversation for those reasons.
We could decide something legislatively different in terms of who do we want this director to be under, and then that goes into how you structure the program. We can do that.
That would be a policy decision for the
For
committee.
us, you're learning the legal, you're becoming one of our lawyers. That would be a policy decision. I mean, that's something we're grappling with. Should it be under WellPath? Because WellPath may not always be with us in 4 or 5 years. It could be another contractor. But if we had that position independent of WellPath, and then WellPath would be the entity that would do the treatment, but not be in charge of it, or the director, that then needs to make that decision if the person has restored competency or not. And it's the director that makes that recommendation to the Commissioner of Corrections, who then makes that determination to the courts. So it's trying to separate
Treatment from
Now,
evaluation.
the treatment from evaluation and just kind of make sure there's enough check and balance there.
And that's currently, I think, how Vermont does the sexual offending programming, the different company than WellPath.
Can you say more about that?
I don't know too much more,
Okay.
Representative Lawley,
But
but
WellPath doesn't do,
we don't do that part of the programming, no.
okay.
It's a different contractor.
Dealing
Yeah,
with
you could contract to whoever you wanted, yeah.
Mayor.
Earlier this morning, we heard testimony about all the different agencies collaborating together to make this work. Where does the line draw for you as far as this conflict of interest, or what you can do or can't do or whatever? Because I have, there's been a little bit of a sense of folks, some saying we don't do it, it's another entity that's part of this group. So where do you find the line drawn in this discussion?
Was that for one
that
of
for
us?
us?
Oh,
Sorry.
yes, yes.
Okay.
Oh, sorry.
I'm sorry.
No, that's okay. So you heard from different
Well,
different.
we heard from mental health this morning and also from the commissioner of DOC.
Okay.
And everyone's talking about collaborating and, you know, making this work. But yet I'm hearing in each testimony, but we don't do this. So how is this process put into place that for the long haul is actually going to work and work well for everyone involved?
They
Hmm.
spoke about an MOU. I don't know that we saw that, but I would think that that MOU would be how they,
Not the current MOU.
Not the current one, they'll have to make one, but as I said, there's some gray areas in these discussions that I'm concerned about.
And that may be more a question back for Haley and, you know, if it's the commissioner of DOC and the commissioner of mental health and an MOU or an agreement around and I think in the bill, the Department of Aging and Independent Living is mentioned as
Right, you're
well.
part of-
I know that, yes, currently we make it work, you know, through the chief of mental health, who we have the MOU around our SFI patients where we meet and we call in the community as applicable if a patient has services outside in the community. I would imagine it would be something similar to that, but I don't know that I have the answer for you. If someone has services with Dale, I would imagine that they would be called into the same type of meeting, but there may need to be an MOU or some understanding that that is going to happen. I think that currently exists, but maybe Haley can speak, I don't know, more to it, or that answers that question.
I don't know that I have much to add there. I haven't been brought into any conversations about an MOU, I think in part because the authority does not exist yet. But I would also just remind the committee that there are various reporting requirements before the facility is even in place. So it's not that this statute is going to pass and AHS is going to make all of these decisions and WellPath is going to make a lot of decisions and they're going to be immediately put into place. There are various checkpoints in which AHS must check back in with the legislature as this process ensues, and the facility would not be put into place until 2028. So there is a lot of time here to have these very important conversations once the authority has been established.
Well, and I do understand that, but sometimes once these pieces of legislation start rolling out, they take on a life of their own. And some of the pieces that we've been told were going to happen don't. And so I appreciate the fact, and I'm aware that there are these points where folks have to report or check in or whatever. But, you know, as I said, there were a couple of the agencies that talked about this big effort to collaborate, and I would hope that would be the case. But as I said, every time there's the question answered, we're kind of punk kicking it to another agency to say, well, they'll handle it. And I would hope we're all hands are on deck to make this work well. I'm wanting it positively for everyone.
Yeah, I just would speak to like, that is the current process within DOC and within, I mean, I can't speak to currently VPCH, but I think that was the practice. If a patient has community mental health services, or it's not case management anymore, there's a change in the title, the way that was funded, but patients that are wrapped up with mental health, DMH is involved in our meetings. Dale, if we have an individual that comes into the facility that has developmental disabilities or Dale services or TBI, which is under Dale, we involve them. Again, our goal is really wrapping a patient up as best we can to support them. So I imagine that practice would still happen. That's sort of a standard of care just within psychiatric and mental health facilities. But I hear what you're saying. It sounds like
it's hard for me to hear, I imagine, or that, and I know we're in the process of getting to where we think we want to be, but you know, often we'll hear, well, this is kind of the plan, but then it doesn't always pan out. That's where I'm concerned. But thank you very much.
Yeah, you're welcome.
Sure. So we you know, we don't know what the staffing levels are going to be yet. That's going to be sussed out still, but we know we're going to need more staff. I'm hoping you could give a snapshot of how many staff do we have in the WellPath contract for Vermont now? How many of those positions are filled? And then could you give us an idea of how many of those are telehealth, you know, and might be based in other states as opposed to on the ground? I'd also be interested in whether we envision telehealth staff conducting some of those competency sessions.
You wanna, I don't know how many.
We may have to get back to you on the full number of staff that we have in Vermont DOC. I don't know the exact number off the top of my head. I know we have about 18 mental health clinicians, somewhere around that ballpark. I'll get you a definite number through Haley. And I
Six
think,
psychiatric providers. Yeah, we can get you the numbers and the vacancies. And as far as telehealth, I think we only have 2 psychiatric providers that are out of state. That I think that is the only telehealth. I could be wrong, but I don't think that there are any other telehealth providers. As far as if we were to do the competency, I would imagine our goal would be to get people in the state. That was sort of when I came into the position, there were mostly telehealth, and we really worked with the superintendents and the sites to get people on site, because that's my belief, is that that's a better model for this type of work, to get people in-house. I have some really strong remote workers, but I prefer to get people in the state and in the facilities. It makes a difference. So,
And are we pretty fully staffed without looking at the actual numbers?
mental health and psychiatry, yes.
yeah, we just might have
Some nursing.
like a few, like maybe 2 vacancies in mental health right now. That don't quote me. I know I'm being recorded, but I think it's around 2. And psychiatry, we're fully staffed.
Psychiatry is
Yeah.
fully staffed, mental health's fully staffed. I can't speak to nursing. That's I know that all the other positions are full, but nursing, I think, has always been an influx, and I don't know the current status of nursing.
Thanks. If you had the numbers, that'd be great to send.
Yeah.
So one thing that is required in language for the forensic facility, besides a clinical services director, it also is to ensure there's a registered nurse who's licensed pursuant to 26 VSA Chapter 28. And that's what I'm kind of trying to find out. It's a whole chapter in current statute, as well as the person or a physician who's licensed pursuant to 26 VSA Chapter 23 or 33 is available to provide care to the person 24 hours a day, 7 days a week.
I take that as on call. Our current system for all the facilities is that we have someone a provider, a physician or advanced practice provider, and nursing nursing is always in the building 24/7. The providers aren't, but we have a pretty solid on-call schedule for both the medical side of things and the psychiatric and the mental health. So there's always someone available 24 hours a day. I think that's what that's probably speaking to.
But the nursing there's a nurse on staff.
Mhm.
Infirmary 24/7.
Yeah, and I don't know that it would have to be.
Well, I think in the majority of our competency restoration programs, sort of depending on where they're located within the facility, we always have 24/7 nursing, whether that individual is actually sitting in the restoration unit or it's just part of the medical unit. Those things kind of get fleshed out. We always have like a psychologist, mental health professional. We call them like mental health techs for WellPath, but they're like bachelor's levels individual who can do activity groups and kind of wellness skills, etc. And then we have psychiatry, and then we'll have some type of physician, and that also is a position that's either dedicated specifically to a competency restoration unit or part of the general medical in the facility.
So if you need to provide this, can you do this in 2 facilities? Because you never know, you may have some women come in as well as men. So you've got 2 separate facilities. And what does that do to your workload and what does that do to the current contract that you have with DOC? Can you provide that within the current contract and the current cost of that contract? Or is the contract going to have to be changed in an increase in cost?
The contract would need to be adjusted because it would be a different scope of services. I think there would be some overlap of services, in particular with nursing and physicians, but we don't currently have a psychologist who could oversee forensic use. So there will have to be an adjustment to contract and additional positions. As far as the two facilities, was I reading the bill? I might be reading it incorrectly. I was thinking that the one forensic facility would be set up to house both men and women, but perhaps I misread that.
Oh, there's a lot of assumptions
Yeah,
and interpretations, and that's what we're trying to work through.
yeah.
That is not what we've been hearing
Today.
today. So you would be having Chittenden facility for the women and then a male facility.
So what you were hearing today was current facilities implementing this program within current
Right.
facilities.
And
Okay.
they're binary facilities. Males are in one and females are in the other.
Hmm.
So you would have to provide services to two facilities. Do you know what your WellPath contract is now with the state, how much the cost is right now?
No,
I don't.
I don't.
know.
It's around 40 million.
Yeah, it's 40. It's exactly around there.
40 million a year.
A year.
A year.
Yeah.
And nothing.
Just chunk.
He's like, I want to raise.
Is right.
So we wonder what this will do to the price of contract, because you're not really charged now to provide treatment or services for competency restoration, correct?
Correct.
Yeah, and what is that going to entail? And staffing on your level? And if there's a clinical director, where's that person housed? And under whose budget is that
Right.
person get paid?
And we were told that it could be managed within the present budget.
$27,000 per year.
For what?
For each person gets $27,000 worth of care.
Right now?
Yes, in the system. But it's costing.
Yeah, I don't, if I can't really speak, I guess, to the operations
Yeah.
of,
We don't do the budgeting, and so we'd have to defer it to the other folks, because we're the clinical ones.
Right, you're the
Right.
political ones. So we are too. So
yeah.
That's
another
not my
part-
strong suit.
Another part within the forensic facility is that, and this is a language that's in the bill, that ensures that people receive clinically appropriate assessment, treatment planning, including the development of an initial person-specific treatment plan within 72 hours following the transfer, and which shall be reviewed periodically as clinically indicated. Is this something that you could provide right now, or are you gonna have to beef up your services?
We already do treatment plans in the mental health. For all of our mental health caseload, we do a treatment plan within 14 days.
No,
Don't-
yeah, it's
maybe-
sooner than that, yeah,
Sooner than that.
I think
Okay.
so, yeah.
But I think that our mental health team, they do see patients within usually hours, if not a day, on business days. Nursing does the initial intake within hours. So that to me doesn't seem challenging. It's at the state hospital, we would develop a treatment plan within, maybe it was a similar timeline, and it was an initial treatment plan that you continue to build on, a person-centered treatment plan where you meet with the patient and then get their input and their goals. And the goal is to get them to align, especially when someone's in an involuntary position. You want to try to get their voice and perspectives and get their buy-in, and especially in competency restoration, I would think. So that is something we do all the time anyway. So I don't think that would be an additional burden ask necessarily.
There's other things here too as well, but I don't want to take up all the time. Other questions? So do you feel that you have enough staff qualifications and licensures and training right now to provide this type of treatment?
No, we would have to add staff. We don't have a psychologist attached to the Vermont DOC contract, and you'll need a psychologist as part of this program, and probably may need to enhance psychiatry hours. And also you'd have to add some staff related to kind of day-to-day programming, the kind of milieu-based programming. So today, no, but we would definitely build a package out.
Any other questions? Anything else you'd like to share with us? I think we're all feeling a little fried right now.
Yeah, it's
Yeah.
late in
Yeah.
the day.
I think we just appreciate you having us today.
Thank you.
Thank you
We
very
may
much.
circle
Thank
back.
you.
I'm not sure yet. We're just still taking testimony.
Okay,
That we're gonna be adjusting the language and we may circle back with you.
yeah, circle back and we'll get you those numbers that you asked for as soon as we
Thank
can
you.
get those. Yeah, thank
Very
you.
much.
That'd
Thank
be
you.
great. Thank you for taking time out of your day today to do this and enjoy Maine.
Thank you.
Thank you, committee.
you.
Right.
Okay, well, kind of whittling down here. We're gonna finish up. I would like to spend time as a committee soon, maybe we'll have time tomorrow morning to kind of just start working in terms of what we need to address for language changes, because we need to start working on a draft.
Mhm.
So I don't want people to start thinking about that. Does that make sense?
Yes.
Yeah, that sounds good.
Haley, we're gonna be around tomorrow morning, dealing on S-13193. We've got the network coming in, we have the mental health law legal aid coming in, ACLU. Jared came in today, so he doesn't need to come in tomorrow.
Do you need directions on how to get here? Yeah.
No, I was planning on being in the room, so I'll see you guys all tomorrow.
And then Friday, what were we looking at? Friday morning, 8:30,
Yeah, that was, Department of Mental Health.
coming
Continuation.
back.
Great.
Be doing
Yes.
that. Anything else before we sign off with YouTube? Yeah, let's go out with YouTube.